We might just give it a few more minutes. I can see registrations are still coming through quite rapidly. Good morning, and thank you for tuning in on our fourth session in the Marsh Cyber Masterclass series. My name is Fiona Fong, and I'm a cyber claims specialist within the Marsh Pacific Cyber team. I'll be moderating today's session, where we will be delving into the anatomy of a cyber insurance claim. Joining us today on the expert panel is Catherine Keith.
Hello.
Catherine is the US Cyber Incident Management Leader at Marsh. In this role, Catherine is responsible for leading Marsh's efforts to assist clients responding to and managing cyber events, including data breaches and ransomware attacks, and advising them on pre- and post-cyber incident management. Catherine is also a lawyer, and prior to joining Marsh, served as head of Beasley Breach Response Services for 8 years. Welcome, Catherine. We also have Nitesh Patel joining us. Nitesh is a cyber and technology legal specialist at Gilchrist Connell and was recognised as an Australian top 10 senior lawyer in this year's Australian Law Awards. His expertise spans technology, privacy, data security, incident response, and cyber insurance matters. Welcome, Nitesh.
Thanks, Fiona. Looking forward to the discussion.
And finally, we have Stephen Lucas. Steve has recently joined Marsh as a managing principal in the forensic practice and has over 10 years of insurance experience across a number of industries. Stephen is a chartered accountant with extensive experience in the delivery of pre- and post-loss quantification of complex cyber and business interruption engagements. Welcome, Steve.
Thanks, Jenna. Hi, everyone. Good morning.
So the intention is to make today's session as practical as possible. We will be working through a mock cyber incident scenario, providing practical advice on how to manage a claim from day one. We hope that you'll come out of this session with these following key takeaways: a better understanding on the importance of a claims protocol and getting the notification process right from day one. Understanding how to respond to a cyber incident and why that is beneficial from both a coverage and protection standpoint. And of course, understanding the interaction between various parties and vendors to a cyber claim. Throughout the masterclass, if you have any queries at any stage, please feel free to type it in the Q&A box located at the bottom of your screen. Let's now turn to the first cyber incident scenario. So you can see here, a client's IT vendor was performing regular updates to their computer system when they noticed malicious activity and certain systems not operating. The client immediately arranged for their IT vendor to investigate and perform any necessary recovery action. The client also proceeded to appoint their own external law firm that they have a close relationship with to provide them with assistance. It was not until 2 weeks after the incident, the client decides to then notify Marsh of the incident and seek recovery of costs incurred under their policy. So before we even talk about the actual claim itself, straight away, there are clearly some issues here from a claims management perspective. Catherine, would you like to share with us some of the pain points in this scenario?
Sure, Fiona. There are several here, and I wish we could do a little rewind of the facts to move the client back a little bit in time. the key to me, what leapt out is the fact that the client is using its own IT vendor to investigate the incident, which might be a natural inclination, and also that they're using their own law firm, which also might be a natural inclination. But when you superimpose cyber coverage onto this scenario, had the client with their broker or on their own reviewed the policy, they might have understood that the carrier has certain requirements around utilization of vendors. And this just points out that planning ahead of time, developing an incident response plan to understand the carrier's rules such that if the carrier, for example, has a panel requirement for vendor usage, that the client understands who those vendors are, and if they're different from those that the vendor might want to use, there's at least a discussion with the carrier. And sometimes the carrier could grant exceptions around vendor choices. But the point there is to do this all up ahead of time so that you're not running into problems with the carrier when the cyber incident is unfolding. It is more the case with cyber, and it's sort of a mindset change that cyber coverage is a little unlike any other type of coverage in that most of the cyber carriers have evolved to the point where they have a service proposition built in to their policy forms, which means that in most cases, upfront breach response services, including expenses related to investigating whether there is a breach, investigating that breach, responding if it is a breach, and all the related services that come along with that investigation and response are contemplated by the policy, but often have pre-approval panel or consent requirements. So understanding the nature of your particular policy and building that into the incident response could have avoided some of the issues that we're seeing here with this fact pattern.
Thanks for that, Catherine. And I absolutely agree with your comments here. I often cannot emphasize enough to my clients the importance of ensuring that the vendors you have appointed have previously been approved by insurers. So line up your vendors in advance. Don't wait until a claim has occurred. All this information really should be pre-approved between the insurer and insured and set out in advance in a claims protocol. Also want to quickly touch on the importance of immediate notification here. So in this scenario, it wasn't until 2 weeks after the incident, the client decides to then notify Marsh. The preference is to avoid delays, and immediate notification is preferable where possible. So in this particular scenario, Catherine, what should the client have done here instead, as soon as they were made aware of malicious activity and certain systems not operating?
Yeah, there's a lot that has to happen at one time. Certainly an investigation of what's going on, fact gathering, what systems were impacted, what potential data could have been impacted, who knew about this, when this was discovered, when it occurred, all of that sort of who, what, when, where fact gathering has to happen. At the same time, as you pointed out, that the broker should be notified, and also the carrier should be notified. So there's a lot of moving pieces that have to occur pretty much immediately and almost simultaneously. Most carriers have a 24/7 hotline or monitored email by which they have either breach coach responders or on-call claims adjusters who can receive that notification. And what that notification does is that it alerts the carrier that this client in particular is likely to need services, and they need to stand by to discuss those services with the policyholder and approve or consent to those services. So that immediate notification that Marsh can help you with is very critical. And the notice to the carrier at this point in the process doesn't really have to say much. It can say, facts here, malicious activity noticed in the system, or certain devices non-operating. The actual emergency notification doesn't have to contain a lot of facts. That can come later. But the point is to notify the carrier right away so that they're not surprised and reacting to a bunch of vendor invoices after the fact. Thinking about, as this unspools a little bit further, the kind of legal guidance that you'll need, and Nitesh can speak to those issues, the kind of forensics, investigatory, technical assistance you'll need. Now, this IT vendor performing the regular updates and doing work for this client may possess or may not possess forensic skills necessary to investigate the malicious activity. This IT vendor is likely not on the carrier's panel. I'm just guessing, but there'll be a discussion around which forensics provider possesses the skills necessary to investigate this, and whether that chosen vendor is on the panel or not, as we pointed out earlier. So in pretty short order, at least legal counsel and a technical forensics expert should be lined up to help investigate this and react to it from a technical perspective and restore the systems of the data if possible. So that's what should have happened in this case.
Thanks, Catherine. Absolutely agree. So here is a slide which sets out the cyber incident phases. At this stage, we are metaphorically fighting the fire here with an emphasis on incident response management. So Catherine has shared with us some immediate first steps and emphasised the need to keep insurers in the loop from day one. The appointment of legal and PR specialists is all part of this incident response management piece. So Nitesh, I might now turn to you. Could you please share with us some legal considerations at play here with this particular scenario?
Yeah, certainly. Thanks, Fiona. And that was a really great introduction, Catherine. Thank you. The first steps that you take when you become aware of an incident can have a really big impact on your ability to properly assess and mitigate your legal exposures. And something that Catherine's already touched on, but I think it's worth emphasising, especially in this scenario, is that there's a lot of uncertainty around what steps were taken in response. So Catherine mentioned the regular IT vendor coming in and there was, all we know is that they're investigating and they performed some necessary recovery action. What investigations were performed? What was the focus? How were those steps documented? Is there any snapshot of the impacted systems? Were the recovery steps documented? The other issue is that there may potentially be a conflict of interest. This isn't necessarily something that's nefarious or underhanded, but the IT vendor may well have done something that they weren't happy or proud of that then led to this particular incident, and they may want to just fix it as quickly as possible. But there's multiple factors at play here, and we need to know exactly what's happened to properly advise. The second part, of course, is that the claimant's law firm, the client's law firm was involved in advising. At what point did they become involved? What advice was given, and do they have the expertise in an area that's really rapidly evolving? So all these issues impact your ability to assess and mitigate potential legal exposures. And so it's really important to get the right structures and processes in place as quickly as possible, and getting the specialist incident response team in will help you with that. One thing that's really worth emphasising as well is that getting all the right people involved from the client is very important, because that will help you make sure that decisions can be made quickly and any information we need is also gathered quickly. And so getting onto the first big legal issue directly is that having legal representatives involved early will give the client the ability to be able to claim privilege over various documents, communications and reports that are created when you're responding to the incident. Now, responding to an incident hopefully isn't something that a business does regularly, and it is a very stressful time, and things are said and decisions are made and actions are done that can sometimes be later regretted. So if you can get some expertise in there quickly, especially legal, we can help control the communications internally and make sure that anything that needs to be potentially protected with privilege can be protected with privilege. The second big legal issue that I wanted to touch on is identifying your notification obligations, because this can really dictate what what the extent of the urgency is in particular elements of the incident response. And it's becoming an area of increasing complexity because there are so many regulators now that are active in the space, and they're taking different steps, and they've got different motivations. And there are many rules and regulations that can apply, and it really depends on each individual business what could apply to them. So just as a snapshot, we've got the Privacy Act, which I think many people are aware of. You've got this obligation to assess within 30 days any incident, and then notify an eligible data breach if that's what this is, as soon as practicable after you've completed your investigations. There's a misconception here that it's 30 days. It's not. It's investigate within 30 days and then notify as soon as practicable. You've got your consumer data right, and that's different again. That's to notify security incidents within 30 days to the ACSC, so the Australian Cyber Security Centre. You've got GDPR, which may apply to some businesses, and that obligation is to notify personal data breaches within 72 hours to the relevant authority, and that sometimes is not as straightforward as it may seem. You've got APRA, so if you're an APRA regulated entity, you have to notify information security incidents within 72 hours. And also separately to that, information security control weaknesses that can't be quickly remediated within 10 days as well, so that's different again. You've got ASIC, where you've got to notify any significant breach of obligations under the Corporations Act and the particular sections of the Corporations Act within 10 business days. And if you're an ASX listed entity, you have to consider your ASX disclosure obligations as well. In addition to that, we've got all sorts of changes coming up. One that I wanted to emphasize is the critical infrastructure legislation. That looks to have a very broad application, and that's going to be looking to impose 12 or 24-hour notification obligations. So that's something to keep an eye out on. It's important to note here that this is not just about personal information or personal data. This is about the incident more generally. And you need to get a grasp of what applies to you very quickly so that you can identify what you need to focus on here and what information you need to gather. And that will really help you shape your incident response. The other side of this is that you need to consider contractual obligations. Increasingly, we're finding that contractual obligations include obligations to notify your suppliers or those who you contract with to provide services, because they themselves will have obligations that they need to comply with. So to keep everyone on side, you need to be across that as well. And this ties in with third-party claims and exposures as well. It's an area we're starting to see a lot more activity in, and I think upcoming changes will mean there's going to be even more activity in this space. So that's a lot to consider at the outset of an incident, and that's why you want specialists who are involved in this to help you shape your incident response properly. And that's where
could I throw in, Natasha?
Certainly, Catherine, please.
I'd like to just support that, because all of what Nitesh said is absolutely true. And when we look at this fact pattern and we see that the client turned to kind of its regular counsel to help it, begs the question of whether the regular counsel possesses the kind of expertise that Nitesh is talking about and that Nitesh possesses. And in the thousands of claims that I've been involved with in breach response, it is the lawyers that eat, breathe, and sleep data breach and data breach issues that are the ones most expert to guide you through. It's not the time to learn on the job, and turning to counsel who possesses his expertise is really super critical. They know who the good forensics are. They know how to work with insurance carriers. They know how all the pieces fit together and make it a smoother experience for you. And while none of this is a fun experience, to have that expertise guiding hand is really critical to a successful investigation and response.
Yes, thanks, Catherine. That's spot on. You know, ultimately we can talk about, and we will talk about all the legal exposures and all the rest of it, but the main aim of any incident response team is to help guide you through this as smoothly as possible. And it's not a comfortable process, but to try and give you some comfort through all of this, that the things are under control and it's being managed properly. And I think that's a good point to touch on, the engaging of a forensic IT specialist and why it's so important to do it properly. So structuring the engagement through lawyers will again help you protect their correspondence, investigation and findings under a veil of privilege where it's available, and sometimes the findings that they come up with may not be something that you'd want released publicly, or at least you want to be able to control the message around that. It'll also help you focus on gathering and documenting the information needed to identify and comply with your notification obligations. And given what we've just discussed about how quickly some of these obligations come up, it's important that it's done pretty quickly. And I think the last thing that's worth really emphasizing here, it'll help you promote an effective response and also help keep the forensics focused on working within agreed scopes, which I think Stephen's going to touch upon in terms of how that will help you with claiming costs and the like.
Thanks, Nitesh. So that's a lot of fantastic material here. You've touched on the importance of having law firm to engage IT forensics to make sure they are acting within a clear purpose and within defined boundaries to promote an effective response. But also at the same time, allowing you to make a claim of privilege over the communication, which is key here, and investigations and findings. I think, Steve, I might pass over to you now. I want to focus more and shift more to a claims management perspective. Would you like to share your insights on the importance for the client to properly engage a forensic IT specialist? And I guess the question that flows is, how does that affect the way costs are subsequently managed and covered under the policy?
Sure, absolutely, Fiona. Look, the reality is you're not alone, and you don't have the answers to everything. What we were touching on before, both from Catherine and Nitesh's point of view, is ultimately insurers have their own forensics and other vendors on the panel. And the purpose of that is as alluded to previously, is that they are experts that are engaged in this field to essentially understand the cause, neutralise the event, understand how best that we can rectify and recover the situation and event. So it's really important there to be transparent early on. So in terms of scope, so for a IT forensics, so we've dealt with a number of claims where, as an example, a IT forensics firm have developed a scope of works to carry out the root cause and investigation, etc. But before that was even agreed or shared with insurers, the work was underway, and then following which, when the costs are collated and submitted to insurers, it was identified that some of that scope of work actually did not relate to the cyber claim. So it was costs incurred after the event that just related to future proofing or risk assessments for the client's IT or OT systems. And ultimately, had we have been able to agree those scope early on and upfront with insurers and had that covered off, potentially we could have avoided some of these costs. And as we know in the market, some forensic costs can have quite high rates, and again, with insurers having their vendors on the panel, they can look for reasonable rates so that no one's left exposed and paying exorbitant costs. So it's really important to be transparent that way and agree on those scopes. And as we said, if you don't properly document this, it can be very difficult to justify our costs. So therefore, we need to ensure that we keep a proactive claim approach. It's a kind of a backward forward step here, because you've had a claim, so naturally you're proactive because you're trying to catch up and fight that loss. But there are definitely a lot of ways that we can prevent that and ensure that we're being proactive and in front of the game. So one of those is around the accurate record keeping, so a creation of a claim template. Keeping all parties up to date and informed, so being transparent with both the insurers. Insurers will usually appoint an adjuster to act on their behalf and correspond with you. But also, importantly as well, for yourself as the client internally, to look at ways to explore and appoint potentially an internal project manager. So somebody that is your direct point of contact, so that when dealing with the insurers, the vendors, experts, etc., there is that right communication channel. So in that way, by having the right communications and claims protocol in place, we can look to ensure then that we are being efficient, we are expediting the process, and obviously trying to look at ways to keep costs down. Also as well, from a claims preparation point of view, there's ways that you can also look to appoint a claims preparer. So if there's claims preparation costs that are covered under your policy, the insurers will allow for that to engage an expert, the claims preparer, to help manage that claim on your behalf, and therefore allow you to worry about what you do best in terms of operating your own business and making sure that you're mitigating the losses and serving your client needs as appropriate.
Just touching on something in particular you said there, Stephen, around the engagement of the forensic and the scoping. The other side of it is that sometimes what the forensic can provide a business or provide the client, some of it falls within cover, some of it may not, but the client wants to do all of this. It's really important from a decision making standpoint, and we've seen firsthand experience of this, that the client is aware what may be covered as part of incident response and what is additional, so that they can make informed decisions about how far they go down certain paths.
Yeah, no, perfect. I mean, that's where it comes down to being transparent. If you're not sure, by all means, communicate with the insurer in terms of what your intentions and approach are, because the insurers want buy-in early on, but before costs are committed to, as an example, and that where it comes back as well to that claims protocol. By ensuring then that we're following that correct channels, we can avoid that bill shock at the very end.
That's fantastic, Steve. This particular claim scenario also mentions that there's certain systems not operating. So aside from all the first-party costs that we've previously discussed, such as incident response management costs, IT, legal, I guess, what are some other first-party cost coverage considerations here? Anything that the client should be aware of in particular?
Yeah, absolutely. I mean, this all comes back to, subject to the terms and conditions of the policy, because all insurance cyber policies are different and behave differently. But essentially the easy way to explain it is, the policy will cover you for costs that are necessary and reasonable. Okay, so and up to the relevant policy limits as stated within your schedules. But you're talking about incident response costs, those PR costs, those costs that help you to navigate your way out of the cyber incident, either it being system damage, restoration, rectification costs. So those costs that are incurred that, before the breach occurred to put your system back into the way it was before that breach. As well as there's potential fines and penalties that may be incurred by the regulatory bodies, which may or may not be imposed. Importantly as well, if your systems are down and you're out for a number of weeks or a period of time, potentially as well, there's business interruption that you may be exposed to, and that may be a way of loss of profit or potential increased costs that you look to incur to ensure then that you can mitigate your losses as need be. Circling back to the system damage rectification costs as well, the costs that you incur potentially here to say, for example, you have your IT team that are working on that project, but therefore that then results in a gap of carrying on with your normal business IT operations. Insurers again will respond by providing cover for increased costs associated with additional resources or labour time or overtime to ensure then that you can carry on your business operations as normally. But look, the reality is, claims do take time to manage, and you are in a frenzy, and it's therefore best to document everything from the start. So as I was saying before about a claims template from early on, to document exactly all the costs that you're incurring. That doesn't necessarily say that those costs may or may not be covered, but from day one, by ensuring then that you're keeping accurate record keeping, it really helps to streamline the claims process effectively, because it's always best to include as much information as you can early on, and then as and when the claim is being reviewed and assessed accordingly, line by line, we can articulate and understand that type of nature of cost incurred, and if it is part of the policy and it can be covered, then it's easy to identify. Whereas if you do, for example, have a claim, you don't do a claims template early on, and several months down the track, you then decide to collate the costs, quite easily, you could look to leave costs out that perhaps you should have or could have had early on. So that's why it's really important then to be prepared in that way.
Thanks, Steve. Some very insightful comments there you've made, particularly around the importance of documenting loss and accurate record keeping. So let's move on and expand this scenario a bit, shall we? You can see here, 2 weeks after the first incident was notified, the client have now advised Marsh they have received an extortion demand, with threat actors advising that they have client-sensitive data and demanded payment of 200 Bitcoin. So it appears the lightning has struck twice here, with the client obviously noticing malicious activity within their systems, also their systems not operating, and now this is followed by extortion demand some weeks later. I might turn to you, Catherine. Is this a common occurrence that you're seeing? Is it a trend that's going on?
Unfortunately, it is. I mean, the kinds of attacks that are happening in recent years and in recent months are much more sophisticated than they used to be, are often sort of dual purpose or multi-pronged in the type of mayhem that is unleashed in your system. Oftentimes, there are what are called banking trojans, and there's a couple of names that you may have read about in the paper. Emotet and TrickBot are two banking trojans that have the ability to scrape data, steal credentials, steal financial information. And often those types of trojans are then coupled with either something like this, which is a demand for money in the form of Bitcoin in order to prevent a release of that data that the Trojans have grabbed. Or, and I know we're not going to get into ransomware, or an encryption. So the launch of ransomware can typically follow the malicious activity by banking trojans. So these investigations are not simple ones. And what's really important is that at the outset, the correct type of forensics vendor is chosen to do the work at the outset, because you want the investigation, the initial investigation, to have been thorough. And for example, potentially here, the attacker, would have been kicked out of the system earlier on in the forensics process, hypothetically, if the correct form of endpoint monitoring tool, for example, was deployed in the first investigation to continuously monitor the environment and alert the client of further malicious activity. So sizing up your forensics choices, as we talked about earlier, because all forensics firms are not created equal. Some skill sets are very good at ransomware. Some are very good at the banking Trojan aspect of things. Some are better investigating business email compromise situations. So vetting your forensics skills and understanding what is part and parcel of a thorough investigation, may or may not have prevented this second incident, because the data that the attacker claims to have and is now threatening to disclose could have been grabbed very early on in the process. But really working closely and understanding through your IT people and your legal experts that your initial forensics investigation was a thorough one can sometimes prevent secondary problems. So here, typically what would occur is that we can talk about resources, specialized resources for this in a moment, but here we would want the attacker to prove to us that they actually had our data, because how do we know? Sometimes these threats are nothing but hoaxes. So, understanding what you're dealing with through forensics and other specialized services is critical to looking at this next phase of this scenario.
Absolutely agree. And Catherine, I think you're spot on in emphasizing that you really need to get your investigations right from day one. And I guess now that an extortion demand has been received, What really should be the next steps here from an incident response management perspective, Catherine?
Well, believe it or not, there are specialists who have business models that have grown up in recent years that deal specifically with communicating with and negotiating with cyber threat actors. So when I entered this field about 10 years ago from an cyber insurance perspective, 10 years ago, if someone had told me that services that carriers would have to provide their policyholders would include ransomware negotiation and Bitcoin procurement services, I wouldn't have known what you were talking about. But this is where we are in the landscape. And there are expert companies who will act on your behalf and negotiate with the threat actor. First of all, in this case, for example, the ransom negotiator would communicate with the threat actor, would try to identify from historical information, having worked on maybe similar cases previously, what this threat actor is typically known to do. A proof of life, which means a sample of the allegedly exfiltrated information would be requested of the threat actor so that we could assess, what do they actually have our data or don't they? And if they have our data, what types of data is it? Is it data that we would be very concerned about if it was released into the wilds over the dark web or on social media? So there is a very important attempt at exchanging that kind of information with the threat actors. And it's amazing the instances where the threat actors will engage in those discussions and provide the proof of life, so that from that point, in consultation with counsel and forensics and the company's internal incident response team, decisions can be made about how seriously to take the threat, what harm would befall the company if this type of information were disclosed. Again, to Stephen's point about transparency, these discussions would be also shared with the carrier, because in many cyber policies, there is extortion cover. So the carrier would reimburse any extortion payment that must be made, or the company believes it should make. But in order to consent to that payment, and often there are consent requirements built into the policy, whereby the policyholder can't just simply write a check through the ransom negotiator over to the criminal. Consent has to be provided, and other kinds of regulatory checks have to be performed. There are certain laws in the US and elsewhere in the world where it must be ascertained that the organization to whom the ransom would be paid is not a terrorist organization, for example. So there are certain checks and balances that would have to go on as part of a due diligence process in the consideration as to whether to pay the extortion to the threat actor. So there's a lot. It's not as simple as to pay or not to pay. Analyzing the harm to the company, working with the carrier on obtaining any consents, doing any regulatorily required due diligence, working through the ransom vendor, are all pieces that would go into settling out this secondary issue that's cropped up here.
Yeah, I might just add on the issues around to pay or not to pay, that will be fleshed out in more detail in our 6th masterclass on ransomware specifically. But today we want to focus more just on this extortion demand scenario. And I guess, Catherine, you made some fantastic points here, especially, I guess we would now turn to more some reputational considerations as well. Nitesh, I might hand over to you. You previously spoke a lot about legal considerations. How about considerations from a public relations perspective?
Yeah, thanks, Fiona. Absolutely. I think the first thing I should mention is 200 Bitcoin, just for context, at the moment is about $3.7 million US. So it's not small change. The ransom or the extortion demand here that's been raised. Given that the threat actors have now told the client about the fact that they've got client sensitive information and they want all this money, it's very likely they're going to probably publicize this more broadly to try and compel a payment if they don't get the right kind of response up front, which in most instances will be, can you pay us some money? So with that in mind, it's really important to try and get in front of the messaging, and it's really important to get the right PR people in as quickly as possible as soon as you see something like this. And you want them to be working with the client's internal marketing teams and the legal teams to deliver the right messages at the right times. This is also going to bring into sharp focus the notification obligations. The threat actors have said here that they have sensitive client data. Now, sensitive client data could mean personal information, could mean personal data, depending on which definition you're looking at, but it could also mean something more broad. And the focus tends to be just on personal information, but you need to really look broader in this day and age, especially with what is being put into various contractual obligations, and given the expansion of obligations around the need to notifying security incidents more broadly. So you really need to think on what triggers your notification obligations here and what are your contractual obligations. You also need to start thinking on potential third-party claims here and regulatory investigations, given that this incident is probably going to go out in the open and it's going to be publicized. And you also want to think about what steps you need to take to mitigate that exposure. And part of that is trying to control the message that gets sent out to try and appease the position, and to the extent there's any uncertainty around the facts, you try and address that to the extent you can. This then really ties back in, I think, to something that Catherine raised, and that's the whole piece of getting the right forensics in up front. There's a real question here of what was done in that first incident, what type of investigations were performed. It's really important that you don't just focus on the current incident in this day and age. As Catherine said, threat actors will nowadays act in quite a sophisticated manner. They'll use what they have right now, but they'll also start trying to build in other ways of being able to conduct a compromise or look for potential pre-existing exposures that the system has. So as part of any forensic investigation, you want to make sure it covers not just, oh, how did this incident occur, but where has that threat actor been? What else might they have seen? And it's just really trying to get that balance right on how far you take that investigation and keeping your insurers involved to make sure that it doesn't go too far from their perspective. And underpinning all those question marks is that there's a strong chance regulators, as well as insurers, might be looking very carefully at what happened in that first incident and how it was handled. So again, it's really important to take those first steps properly when you get an incident that comes in and you need to respond to it. Businesses will also, of course, need to look very carefully on whether or not they go down the path of paying extortion. And I think, again, Catherine's addressed that really, really well. This landscape is changing, so it's something to just keep an eye on, just to see how things will be developing in the near future. And I think with all this, I think one of the key messages around all of this is to make sure you keep your insurers informed through this whole process.
Thanks, Nitesh. So as with any system compromise or extortion demand claims, after we've dealt with the incident response management phase, we find that our clients now turn their attention to the claims management phase. And obviously, in particular, the recovery of business interruption and other first-party loss. So, Steve, I might pose to you this question. What can the client do here with this scenario in order to maximise recovery of costs under their policy?
Absolutely. So, look, there's clearly a number of moving parts to this claim. You know, we've touched on the first-party costs, the possible extortion costs to consider, the BI, and even potential third-party costs that may be imposed here. It's really important, as I was saying, to subject to the terms and conditions of the policy, etc. In terms of how we then approach this claim. I touched on previously about a claims template. That's really just a record-keeping document that you can design or say from us that we can provide as well. But it's really about just a documentation, whether it be, say, an Excel spreadsheet, about how we can document exactly those costs that are being incurred. And a really easy way to even do that is to create a separate insurance code or ledger in your accounts, so that all those costs that are being incurred, that you're capturing within a separate ledger, so that you can look to separate and identify those individual costs that can then be put into a spreadsheet to identify those type of costs that are being incurred. Obviously, a big question around this will be around indemnity. So, when will an insurer grant indemnity, etc. It's a difficult one to say, but going back to what we were saying about the transparency, the communication, keeping insurers abreast of the situation, that helps to speed up the granting of indemnity and therefore allowing them for your costs to be covered under the policy as well. So, if we're talking about, say, the business interruption, there's a number of other things to consider within the policy. So first and foremost, in terms of a waiting period or a time retention that policies may touch on, sometimes it could be, for example, an initial 12-hour waiting period, in that any losses that continue to occur beyond that 12th hour, the BI will be triggered. Now, with the system rectification, those costs being incurred, the forensic costs, etc., that doesn't fall under that time retention. It's only around the BI. But clearly here, when we're talking about a number of weeks following the incident, that there is continual issues or impact to your business, one would like to think that in terms of those time periods that you'll be okay. So from a BI aspect, we've got to think and consider here about any potential loss of sales that may occur. Generally, under the policy, the cover is afforded to the insured for your net profit plus your fixed costs, directly related to that cyber event. And it's really important to remember that if you have a BI loss, it needs to be a direct cause of that cyber event, and not for other external or outside factors that are not related to this event in itself. So, understanding from your detailed P&Ls, looking at sales statistics, forecasts, etc. However, whatever industry that your business is in, it's to really try and understand, if there is a dip, is that due to that cyber event? And again, there are a lot of experts and claims preparers, etc., that we can help to assist in that way. There are other increased costs under the BI. So, if you're incurring costs for increased overtime, so making sure that your team are being remunerated effectively, in addition to the normal salary or your normal cost that you do expend, to ensure that you are mitigating. Because under your policy, the advice that we give to our clients is to act as that prudent uninsured. So what would you have done had you had no cover in the first place? And clearly from a business continuity, your first response is immediate, that you want to protect your brand reputation, image, and do everything you can to ensure that you're not exposed there, and therefore incurring such costs, which if it's necessary and reasonable, will be covered under the policy. So just touching all of those, and as part of a normal claims preparation process as well, from a timing perspective, as and when that information is collated and supported by way of, say, invoices and as I was saying on the BI, we can then look to submit interim claim submissions, which will then help with timely process of insurance proceeds and payments, to ensure then that your cash flow is not restricted, and therefore ensuring that you're getting those timely receipts of payments as and when they're required. And potentially the last point as well to consider here is about any betterment. So some policies may or may not provide cover for betterment. So in other words, improvements or strengthening your systems that as a result of the event, yes, you are covered for putting you back to that to the day before that breach, but any potential betterment, etc., that you may incur may or may not be covered. So again, that's really important to consider there. And sometimes with those betterment costs, they can be quite high. And again, you know, that you want to make sure that we're avoiding any bill shock at the very end. But as I say, that circles back to that transparency piece, that as long as the carriers, the stakeholders are on board, these type of things are addressed early on.
Yeah, Stephen, and that's yeah, exactly right from our experience as well. It sometimes is the case that even if these costs are not covered, if you're upfront and transparent about what's about to happen, the business at least can make an informed decision about whether or not they want to proceed with something that may not necessarily be covered, regardless, because it's going to be so beneficial for them.
Yeah, maybe one last thing too, I might just say in terms of the business interruption as well. You know, you do have a defined indemnity period. Okay, so you know, from day one, under the policy, you may have, say, a 3, 6 month or 12-month indemnity period that will cover you for your BI. So it's really important to remember that. And especially if you say you have a 3-month indemnity period cover, from day one up until that 90th day, you're covered for that BI. And so any costs incurred beyond that is unlikely to be covered. So it's very important to remember that as well.
Thanks, Steve. Some detailed insights there on how the client can maximise the recovery of their loss, first-party loss, in particular business interruption. So I guess hopefully by now we would have reached towards the end of a claim's life cycle. You know, once the insurers have made payment of the claim and all outstanding issues under the incident response management piece previously mentioned have been closed out, the matter can then hopefully be resolved. Unless Catherine, Nitesh or Steve, you have anything else to add, that concludes the formal part of our masterclass, and we might turn to the Q&A.
Well, just to say that there could be, in certain circumstances, unfortunately, some third-party claims that might come in post the incident, either in terms of lawsuits or regulatory enforcement actions. So as much as we would like to think of cyber coverage as having a short tail and closing out incidents in rather short order, there can be a much longer tail if a regulatory authority opens an investigation into the matter, or there is a lawsuit filed or lawsuits filed. And there may be provisions in the policy, just to keep in mind very quickly, around consent to defense and consent to representation in those matters, which may be a little different procedure from the approval processes that are applicable in the incident response arena. So just something to keep in mind post wrapping up the incident itself.
Thanks, Catherine. We've got quite a few queries that's come through. We may not have time to address them all today. So if there are queries that we have not been able to address, please feel free to send them over to us after the session and we can address it directly with you. First question we have is, can you share an example of a cyber claim template? What is needed for file for these? I might pass this over to you, Steve. I assume they're referring more to the collation of costs template that you're referring to.
Yeah, absolutely. Look, it's really around an appropriate worksheet that is just creating a ledger to support and reconcile those costs being incurred, whether it be from an insurer or say from Marsh's point of view. We do have draft templates that can assist you through that.
Fantastic. Mindful we are running out of time, might fit another one in. What is Marsh's view on how the insurance market will respond to silent cyber threats and losses under non-cyber policies? For example, D&O casualty. Nitesh, I might pick on you for this one.
Yeah,
I know
sure.
it's a very
Thanks for that hospital pass, Fiona. Look, in all seriousness, it is a complex issue. This concept of silent cyber is an interesting one from a legal perspective, but ultimately, in a nutshell, its policy is not actually intended or designed to cover cyber-related incidents, covering some part of those cyber-related incidents. One example may be your PI policies or your D&O policies. And look, With discussions that we've had with various insurers and just having our ear to the ground in the market, there's very different approaches being adopted here, and it's some insurers are taking the approach of, well, we'll put in exclusions for cyber-related incidents in our non-cyber policies and then look to cover everything in the cyber policies. Others are looking to do it the other way around, so their cyber policies will only cover direct cyber-related matters, and anything related to the provision of professional services or any claim of negligence might be covered by those more traditional policies. I think the real key here is that there is no specific clear answer on how the market will look to go, and it's really important to work closely with your broker and with your insurer to make sure you don't have any gaps in your cover to the extent that that's available in the market.
Thanks, Nitesh. Unfortunately, that's probably all the time we have to answer the query that's coming through. Again, we welcome you to contact myself or any of the panelists with any queries that you have that we weren't able to respond to today. We also note this session is recorded and will be distributed by email to all the registration parties who have made a registration. Might just add as well, we hope today this session has been helpful and helped you to understand these 3 key takeaways. We still have 2 more sessions left in our Cyber Masterclass series. The next session is on identifying your top cyber security risks and will be held next Tuesday, 1st December at 12 p.m. Further, we have touched on an extortion demand scenario today, and if that is of further interest to you, Masterclass 6 is all about ransomware, including discussions on the thought process around insurance policy, including to pay or not to pay, who makes the decision, and what your policy covers for. So that session will take place on Thursday, 3rd of December at 12 p.m. Again, thank you for tuning in on the anatomy of a cyber insurance claim. We hope you found this session informative, and thank you to all our panelists for sharing their insight with us today.